5 seconds. Start. The trial court also held that the onus to prove that the agreement to sell in question was not intended to be an agreement for transfer of the property. Rather, it was intended to be executed as a security for repayment of loan amount taken by him was upon the defendant stop. However, he has failed to prove his plea regarding the agreement being a document of security for repayment of loan stop. The only witness examined by him has admitted in the cross examination that he was not even present at the time of the execution of the agreement in question stop. Hence, the trial court held that the agreement to sell stands proved as per the requirement of law stop. The defendant has not been able to extract anything from any of the witnesses of plaintiff to show that the agreement was intended to be a security document for repayment of the loan stop. Aggrieved of this judgment and decree, the defendant filed an appeal before the lower appellate court full stop. However, the lower appellate court also dismissed the appeal filed by the defendant stop. While dismissing the appeal filed by the defendant, the lower appellate court also upheld the finding recorded by the learned trial court that by examining the attesting witnesses, the plaintiff has proved the agreement to sale in question stop. The lower appellate court also recorded a finding that the defendant has failed to prove his plea regarding the agreement in question being a security document for repayment of the loan which the defendant claims to have taken on interest stop. Aggrieved against the judgment and decree, the present appeal has been filed by the defendant stop. While arguing the case, the learned senior counsel for the defendant appellant has submitted that the lower appellate court has gone wrong in law insofar as it has not even dealt with the evidence pertaining to the legal notice sent by the defendant, whereby he had terminated the agreement in question stop. Therefore, the findings recorded by the lower appellate court are incomplete stop. Still further, learned counsel for the defendant has argued that once the agreement stands terminated, taken unless the same is challenged by the plaintiff and a declaration of termination as illegal is sought by him and granted by the court, he cannot file a suit for specific performance stop. The support his argument, learned counsel relies upon the judgment of the Honorable Supreme Court